And President Muhammadu Buhari has told a federal high court in Abuja that he did not order the Senate to remove the contentious Section 84, subsection 12 from the amended Electoral Act of 2022. Contrary to the claims of the People's Democratic Party in a suit instituted against him and 12 orders on the Electoral Act, the president said he only expressed reservations and concerns in respect of the aspect of the Electoral Act. His position was contained in the counter affidavit filed at the Federal High Court in the nation's capital at the instance of the Attorney General of the Federation and Minister of Justice Abubakar Malami. In their joint counter affidavit, President Buhari and Malami debunked the claims by the main opposition party in the suit, insisting that the PDP suit has become academic and constituted an abuse of the court process. On the strength of the pending Court of Appeal matter, the president and the AGF asked the court to dismiss the suits. And with permutations and controversies surrounding the Electoral Act concerning who is qualified to contest in the 2023 elections and who isn't, political affairs analyst Adewale Ajadi joins us now on the news. Well, thank you so much for joining us. Now that the president has said he did not ask for Section 84, subsection 12 of the Electoral Act, which stipulates that political appointees resign before contesting be expunged, at this point, is the 84-12 substantive or not?
Well, good evening. The fundamental issue is that this issue is before the courts. As you know, we have three arms of government. And firstly, your bulletin says the president might have ordered. The president has no power to order the legislature to do anything. There is an existing decision of a competent court on this issue. And until that decision has been overturned, that's going to be the subsisting decision in Nigeria. That's what's going to be applying. Because the court can pronounce on the constitutionality of any legislation, whether it fits within the Constitution or not. And so we're going through a process. So the significant issue is that we await the Superior Court's decision if it comes, but until then, the court decision starts.
Well, there is a pronouncement of the court on this matter, but in addition to the court's order for the Attorney General to delete that section, now, is it something within the powers of the Attorney General to do?
Well, if it's a court order, the Attorney General has to comply with the court order until another court order has to proceed. So as it stands, the court order is that section of the law, of the act itself, is unconstitutional and it doesn't exist as current law in Nigeria. That's the situation. Now, if another court, meaning the appeal court, pronounce that the section is constitutional, then the Attorney General would have to comply. So the situation now is that there's a court pronouncement. Nobody can, we have to follow the process, simply is what I'm saying. This is why we have a court system. We have to follow the process of the law. The process of the law has been decided so far by the judiciary and is being applied in this manner. And until there's another decision otherwise, that's what we're going to stand by.
Well, another angle to this development is that so far we've had serving political office holders declare their intention to contest in the elections, and some have refused to resign. Now, according to the Speaker of the House, Femi Gbajabiamila, he spoke on this same matter, and for him, he thought that why go through with it in the first place, saying the election of appointees who are yet to resign can actually be annulled. Now, what would you make of this?
Well, the truth about it is that I'm sorry, my phone is going to switch that off. The truth about the matter is that the people who are affected by this decision should not actually willy-nilly comply with what the Mr. Gbajabiamila is saying. My own thinking is that they should ask advice from their lawyers and, if necessary, join themselves as third parties in any existing court case to determine what the court's position is as it affects them. But to unilaterally act and say that they are excluding themselves outside the constitutional provisions that affects them would be acting to cut their nose in spite of their faces. My own view, it's a view, it's not, this matter, as I said, is before the court. This is just a noble opinion that nobody should limit themselves outside what is the legal position that the court has given.
Well, Adewale Ajadi, political affairs analyst, thank you very much for joining us on the news and for your contribution.